Now let's assume that we've all organized our procedural order. We already know who is going to be doing what at which date. We have got all the pleadings in, the bundles in, and we are now also having organized the physical hearing location. We are here now. It's 9:30 in the morning and it's the first day of the hearing. What's going to happen? Usually then, the claimant will open their case. Now, some tribunals will require the party to have an opening statement. And that opening statement would be to basically summarize what their case is about so that it forms like an overall roadmap to the arbitration and the issues in hand. Once that is done, then the witnesses are starting to be called.
This lecture concerns the constitution or composition of the Arbitral Tribunal through the appointment of arbitrators. The main topics are: first, the parties' considerations when appointing arbitrators. Second, the procedure of appointment by the parties, co-arbitrators, institution, and the court. Third, limitations in arbitrator appointment.
The practice of tribunals appointing their own experts is generally rare. Where there is incongruity between the different experts as provided by the parties, it's a common practice to hot tub the experts to try to understand how their different arguments can coalesce, or even to invite the experts to provide a joint statement or report. That being said, as we run through this, you'll see a lot of similarities. The expectations of a tribunal-appointed expert are very similar to that of a party-appointed expert because, as we go back and underscore, the obligation overall of each expert is to the tribunal, regardless of which party appointed them, meaning either the tribunal or a party. So tribunal is usually going to consult with the parties if they're going to appoint their own expert. And so the rule guides us at Article 6 that the tribunal may appoint one or more independent experts to report on specific issues that may need more clarity.